All right, staying with the story now, we are now joined via Teams by legal analyst Mr Kabelo Seabi to weigh in on these developments. Good afternoon to you and thank you so much for your time. So the magistrate will obviously make his decision sometime later this week. How likely is this case to be struck off the roll? I mean, on the one hand, the state insists it has enough evidence and that it has in its possession more than 80 million individual pieces of reading material, which translates to about 14 to 16 terabytes of data, and yet they asked for a further postponement of 4 months for further investigations.
Good afternoon. There are two pieces of legislation that are going to be considered in that application. Firstly, you have the Constitution in terms of Section 35. An accused person is entitled to have a matter start and be finalized without undue delay. Then there is also a provision in the Criminal Procedure Act. This would be Section 342 capital A, which provides that any delay in the prosecution of a criminal case should be investigated by the court. And that is what the magistrate is intending to do. The magistrate is intending to investigate the delay in the matter, and it will depend as to whether that delay is undue, and the operative word there is undue or not. If the delay is justified because of the voluminous investigations and because of further investigations that the police or the prosecution needs to engage in, the magistrate may find that the delay is reasonable. But if the delay is undue, then the matter, because the accused have not yet pleaded, may be struck off the roll. Being struck off the roll does not mean that the matter is concluded. It can be re-enrolled again at a future date.
Just talking about, what Magistrate Stanley Jacobs is asking for. I mean, he's now postponed the case to Thursday, of course, because of some administrative issues. But he also said that there were about 5 to 6 issues he sought to clarify with the investigating officer before ruling on the matter, as you rightfully point out. But seemingly the defense was taken off guard and was not aware of the investigating officer coming to the stand today. Just speak to us about how likely this development pertaining the investigating officer will prejudice the accused's right to a fair trial, as the defense alluded to earlier.
I'm not sure exactly why the defense would be surprised or taken by surprise. Section 342 capital A of the Criminal Procedure Act obliges the magistrate to investigate the delay. And in doing such an investigation, the magistrate will be duty bound to hear what is the cause of the delay. And the person that is best suited to tell the magistrate as to what is the cause of the delay would be the investigating officer. And the defense obviously will be given an opportunity to cross-examine the investigating officer to dispute his evidence if he says that there is no undue delay in the matter.
And I mean, of course, we heard from our reporter a little bit earlier on that the state says it is ready, with the trial. It has about 90% of what it actually needs, but still needs that further postponement to investigate and also interview some witnesses. The state also wants racketeering charges added to the list of charges and wants statements, as I said, from overseas witnesses. How important is this process and the addition to this charge?
Look, a criminal trial is supposed to afford both sides a fair opportunity of presenting their case before the court. So in investigating whether there is any delay, the court must look at fairness towards the state as to whether have they been given enough time, have they been given the latitude to be able to conclude their own investigation or not. There's a balancing act between the two as to whether the delay that is being caused in the case, is it justified by the particular circumstances of this case or not?
And in fact, the defense is saying that the delay is way too long. I mean, it's been over a year. The stakes are high for the state to ensure that it has, a watertight case. Just given how it fumbled and lost its first state capture trial, the New Lane case, where all accused in the case were summarily acquitted because of the lack of evidence against them. What should the strategy be for the state this time around?
One would expect, and I think it is incumbent on the state to make sure that when it goes to court with any criminal case, that they have gathered sufficient material in order to ensure a successful prosecution. The state, you must remember, carries the burden of proving the guilt of an accused person beyond reasonable doubt. So prior to going to court, the state needs to make sure that it has enough evidence in order to reach that benchmark of proving the guilt of the accused beyond reasonable doubt. It is not advisable for the state to start a matter where there is still gaps in its case which can jeopardize them being able to prove the case beyond reasonable doubt.
Mr. Seabi, thank you so much for your time this afternoon. Really do appreciate your analysis. A legal analyst there, Mr. Kabelo Seabi, just weighing in on that earlier court case.